But since then, one lawyer filed a motion to recuse Brian Steele, and another lawyer filed a motion to quash that show cause order. Now, the show cause order was an order saying that the attorney, Kayla Bumpus, would have to come to court along with all the other people who were present at that secret meeting, that little secret meeting that got out. Yeah, the judge was like, I want to know who the snitch is, and I want to know who the snitch is now. So they're all going to have to come back to court. And the Kayla Bumpus, the attorney, one of the attorneys that was in the case, said, actually, we're going to go ahead and quash that. I actually don't think I should have to come to court. So go ahead and throw that out in the trash where it belongs. So let's go through those two orders today, those two motions today, rather. Number one, the motion to recuse filed by Brian Steele or Keith Adams, somebody on that team. And number two, if we have time, that motion to quash the show cause hearing. I'm sorry, I'm distracted today because there's a lot of noise going on outside my window, but fuck it, we must press on because child coverage doesn't stop even when there's construction going on. So let's pull up that first order. Here's the motion to recuse. First and foremost, I want everyone to know I have not read this motion. I have not had my coffee and I hate my hair today. So fuck it, what could possibly go wrong? We ball. Actually, let me go get my black tea. I said coffee. Let me get my black tea before we do this because it's going to be a lot. I'll be right back. Got my black tea. Let's get into it. First of all, this motion is 27 pages long. Girl, we're going to have a time today. All right. So State of Georgia versus Jeffrey Williams, defendant. So this was filed by Jeffrey Williams' attorneys, Brian Steele or Keith Adams. He has two attorneys. So one of those two attorneys, we can see at the end when we get there in the signature page, which attorney actually filed this. But it starts off with the heading, which is motion to disqualify/recuse Judge Glanville from all further dealings in the above referenced case, and a motion for mistrial, not a 2-in-1 combo. So it's got a motion to disqualify, which means judge, get the fuck off my case. Sometimes respectfully, but this time I think it might be disrespectfully. Get the fuck off my case. But there's also a motion for mistrial, which means mistrial. I think everybody knows what that means. Case over, case closed. My client goes home, goes free. Thank you very much, ladies and gentlemen of the jury. We will no longer need your services. That's what this is. And it says, which was goaded by the improper conduct committed in concert by the court and the prosecution. So the court and the prosecution working together in that little private meeting. Y'all, this is so good. Okay, let's get into it. So this first paragraph, the one above the one, the number one, is going to be always going to be comes now. So that's just like a lawyer phrase for this is the defendant's motion. Now, as an attorney, you're always writing the motion for your client on behalf of your client. So this is, you are basically saying comes now your client, Jeffrey Williams, and bringing this motion. So let's go ahead and get down to the facts. So a good motion is always going to start with the facts of the case and then talk about the law and apply those laws to the facts. So that's something that you learn in law school and your legal writing classes. That's typically how these motions begin and how they go. So let's start here with the facts of the case. On Monday, June 10th, 2024, within 5 days of the filing of this motion, the court, along with the prosecutors, engaged in an unlawful improper ex parte meeting. Periana, along with other persons, a sworn witness, Kenneth Copeland. So we get here and we start talking about this sworn meeting, the ex parte meeting, the private meeting. And you see this order of use immunity right here under the second paragraph. And what they're essentially saying is that there was an order of use immunity. So Kenneth Copeland had been granted immunity on Friday, June 7th, 2024. And in a couple days, I don't know when the meeting was, but the order of use immunity had been filed on June 7, 2024. And there was no notice of the ex parte meeting with the defense attorneys. And they're calling this meeting a star chamber meeting that occurred, interesting, when Mr. Copeland had previously been called to testify on Friday, June 7, 2024. And he asserted the Fifth Amendment privilege in open court. We all saw that, baby, in front of the jury. And that's a red flag. Not a red flag, but that's a big no-no. You're not supposed to allow a person to plead the fifth in front of the jury if you know they're going to plead the fifth. So that's another one of the arguments here. I do think eventually the appeals court is going to have a motherfucking ball. The appeals court is going to have a ball with this case because there are so many things that have just gone so far left field. That is if the jury even gets this case, which is a whole nother question, because are these jurors going to be able to sit there throughout the entire pendency of this case, which is slated to last at least through 2025? I don't think so, but maybe they will. So Judge Glanville and the prosecutors essentially admitted, thank you, by silence and by statements in open court, that an ex parte meeting occurred on the morning of June 10, 2024, only after undersigned counsel revealed, based on information and belief, that this impermissible meeting occurred. So if we go back to the meeting, if we go back to the video, you see Judge Glanville was the one who essentially, I'm tired, y'all, but we're going to push through. Judge Glanville is the one that essentially said there was an ex parte meeting. He said ex parte meeting before Brian Steele ever said ex parte meeting. So yeah, I agree with that part. There was basically a confession that this ex parte meeting occurred. So if we go back, we go further down, and if you think about my video I made previously, if you watched it, if you didn't watch it, go watch that or not, whatever you want to do. There was a discussion about a transcript, and it appeared to me that there was some sort of transcript at this ex parte, at this private meeting that the judge just didn't want to give over. And right here, you see Brian Steele in this motion on page 2 allude or talk about this transcript directly. He says that the court denied undersigned counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based on this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, fair trial, fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under the Georgia Constitution. You have a right to be present at every critical stage. I think that's the strongest argument, right? So there were some arguments I made last week about the right to confront witnesses against you, the right to cross-examine witnesses, the right to know information. But really, I think the strongest argument is the right to be present at every critical stage in the prosecution, which, you can really boil that down. Critical stage. Something critical that's happening during the case at a certain time period in the case is a lot more complex than that. But once a trial has started, absolutely the things that are happening after that are critical stages in the trial process. And so this was certainly a critical stage that he had the right to be present during. So let's go back down, and now we're going to get into some of the dense part, and we're only on page 3, child. We got a long way to go. So but if you like this type of content, please let me know in the comment section. So now we get to the Uniform Superior Court Rules, Rule 4.1 and Georgia Code of Judicial Conduct 2.9. So let's go into what those are, and they're going to spell it out here. So let's start with the Uniform Superior Court Rule 4.1, which generally prohibits ex parte communications. Generally prohibits. This is something I wanted everybody to understand when I was making my videos, and I could have explained this a lot better. So ex parte meetings are not always disallowed, right? There are instances in which you can have an ex parte meeting, but generally you should not be having these ex parte meetings, particularly during a trial, and particularly this kind of ex parte meeting where there's a witness who was sworn in who just pled the fifth. But let's continue on. So ex parte communications are generally prohibited except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceedings. Ex parte hearings are only authorized in the case of extraordinary measures, such as temporary restraining orders and temporary injunctions, things like that. But in other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objections that may be properly registered. So that's essentially saying that ex parte communications, ex parte hearings are generally a no. More than generally, like 9 times out of 10, a no, except for in these limited circumstances. We didn't have any of those limited circumstances here. We did not have a restraining order. We didn't have an injunction, which we can talk about at a later time, but we didn't have any of those things in this present case. So we shouldn't have had an ex parte hearing. So now we go to Conduct 2.9, assuring fair hearings and averting ex parte communications provides, and that's all that good stuff. You can read that on your own time later. But essentially, these are kind of all of the violations that occurred, and putting rule numbers and statutes and things of that nature is certainly going to help your case, because you need to know, okay, what are the rules that were broken? What are the laws that were broken? What are the conduct and ethical rules that were broken here? And how do we go about fixing that? So again, we finish here with where it says the court violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team and is biased against Mr. Williams, and the favorable to the prosecutors. Start over. The court has violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors as objectively demonstrated on June 10, 2024, as well as throughout the pendency of this case. Basically said the judge and the prosecutors are batting for the same team. Have mercy. Well, I don't know if he's wrong. Let me not say that. How do I say this professionally? It certainly appears, you can understand why one would think that. And that's just as much of a problem, because you can't look like you're on the same team as the prosecution as a judge. You're basically only supposed to be the umpire. You're just there to resolve these arguments between the two parties, rule on objections, and call it a day, right? You're not supposed to be in the trial making arguments or siding with one person over the other. And the defense attorneys here are alleging that that's exactly what happened, scathing. So it says here, the trial court rejected undersigned counsel's substantive requests for information about the unlawful ex parte meeting, and the court denied the motion for mistrial. Right. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. The prosecutors sat mute and permitted the injustice to occur, and for the court to attempt to intimidate undersigned counsel. So that was really confusing to me as well. So the prosecutors just sat there silently. They didn't say anything. And I think they should have. I absolutely think they should have, because as a prosecutor, you're not supposed to be there to have the defense attorneys get railroaded or see some injustice happening in court and say nothing. If your whole job is supposed to be about justice and fairness, you're seeing an injustice happening right in front of you. You're seeing a defense attorney getting railroaded, getting run over by the court, getting attempted to be a judge attempting to intimidate him in front of court, and you're not saying anything. That's a problem, and you should be standing up and saying something. And this is another reason that people don't like prosecutors. And a lot of people know that I was a prosecutor, and I have a lot to say about that, but this video is not about me. But I do think that if I could go back, I would have thought about my job a lot differently. I would have thought a lot more before taking that position. But again, that's a different story for a different day. So the later Love is who's the lead prosecutor in this case, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutors still remained mute. Baby, there you go. Everybody on mute. Stick around, everybody on mute. So if we go to paragraph 7, undersigned counsel declined to join the antics in ignoring rules and ethical provisions, and declined to provide information requested by the court. Not declined to join the antics. This is insane. Relying on State Bar Rule of Professional Conduct 1.6, which states important pertinent part. And this Rule 1.6 is important, baby. So let's go through this whole thing. A lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures. Long story short, I said I was going to go through the whole thing. I'm not. But basically, you have this responsibility to your client not to reveal confidential information, period, point blank period. But let's go back. Let's go down here, because this part is bolded. Whenever an attorney bolds something, you know it's important. So it says the attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of lawyer-client privilege, client-lawyer confidentiality, applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by Georgia rules of professional conduct or other law. So essentially, the attorney-client privilege applied here, and the attorney-client privilege protected Brian Steele from revealing the source, and the judge was dead ass wrong for holding him in contempt. That's what this is saying. So the court then ignored those ethical rules and continued to demand that the defense attorney reveal the source of information, claiming that the way the undersigned counsel obtained the information was somehow unlawful, and basically accused the attorney of eavesdropping, which is insane, which is a crime. It's not just a small little accusation. That's a crime that's committed that he can be prosecuted for. So when you're going to accuse the defense attorney of doing something illegal to get the information, again, huge problem, especially when it's baseless. In response to the accusations and the impermissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent, and declined to provide information which had been proffered. The court is so biased against undersigned counsel and or Mr. Williams, the court ignored all laws and pursued contempt. Ridiculous. I don't even think I need to recap that. It is what it is. Then the court ordered a written order of contempt and incarceration, imposing the maximum sentence of incarceration for 20 days. Ridiculous. So right here we get into the nitty gritty of why and how this case needs to be heard at this point by a different judge, right? So that's what a recusal is. A recusal is get off this case. This particular, especially this contempt motion specifically, that's what they're talking about here. This needs to be heard by somebody else, not you. You have already shown a lack let me not say that. You have demonstrated that you are biased. That's a little bit nicer. You have demonstrated that you are biased. As a result, you need to get up off this case. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Another judge needs to tap in. Here, the court involved itself in these proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. We're having another issue or another question about conflict of interest, which if you'll go back in time a little bit, you'll see that the Fonnie Willis hearing was about this same issue, this conflict of interest. We're seeing this a lot, not a lot, but more than I would like in Fulton County. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. So the court should have at that point stepped away when the ex parte allegations were revealed, when not even allegations, when Brian Steele revealed that there was this ex parte conversation. The court at that point should have backed away, said that I'm not going to handle this. I have to recuse myself. I'm a witness in this. I was a part of the ex parte conversation. Obviously, it's not ex parte if I'm not a part of it. And the judge should have backed away. But at that point, not only did he not back away, he ruled on the contempt and then issued an order for Brian Steele to go into custody. Insane. That is egregious, in my opinion. And here we go again. The prosecutor sat mute again while the court attempted to interrogate and intimidate another member of the bar who reported a violation of law. Exactly. And the prosecutor sat there like they didn't know what was happening. They didn't care what was happening because to them, it's really frustrating and disheartening to see because it starts to feel like to them, they simply want a conviction at all costs. Doesn't matter what the cost is. That's what they're there for. They don't care what's happening on the other side. They don't care if these ethical violations are happening. They don't care if these illegal violations are happening. Doesn't matter. As long as they can get the handcuffs on Young Thug and his compatriots or his comrades at the end of the day, that's all that matters. It's sickening. In a negative way. The court denied Mr. Williams and undersigned counsel their due process rights. So whenever you have this criminal hearing, whenever you have a hearing like this, you want to have your due process rights. So when due process, the right to hearing, the right to be heard, the right to counsel, the right to have the charges presented to you, and the right to cross-examine witnesses, the right to call witnesses, all of these kind of due process rights that you have that were not present here. So it says here that the due process rights that Mr. Steele should have had were the right to adequate notice and to be heard, to call witnesses at a hearing, to be represented by counsel, all that stuff that you'll hear in court when a prosecutor is taking a plea deal with you, for example, and you are waiving all of these rights. So you're waiving these rights, these kind of due process, not due process rights, but these rights to have a trial associated with the trial. So the right to call witnesses, cross-examine witnesses, those things, those are all the rights that you're waiving. So you'll hear those things too when you're in court and you are listening to a plea soliloquy. So we're talking here more about how the court abuses authority, all that good stuff. But let's go down here and let's get deeper into the motion to disqualify and or recuse Judge Glanville and get into some of the nitty gritty and the deeper parts of it. So now let's get into the nitty gritty. How many times am I going to say nitty gritty? Let's find a different word. So let's get into the requirements for a motion to recuse and filing a motion to recuse. So the Georgia Supreme Court has said that the motion to recuse should be filed no later than 5 days after you find out or learn about the grounds regarding the disqualification. So here, that motion was filed no later than 5 days. That's why they had to file it so quickly, because the timeline is fast to get this motion to recuse or disqualify a judge in. So then we go down here and we talk about these numerous instances in which the judge has exhibited biased behavior towards Mr. Williams' counsel and partial in favor of the state. Here's a case. It says Millhouse versus State. And this case stands for the contention that a trial judge's derogatory or prejudicial statements and demeanor will be considered so long as a reviewable record has been completed. One method of creating such a record is to obtain testimony from witnesses who were in the courtroom at the time of the incident in question. So a judge's demeanor, rolling their eyes, maybe smacking their teeth, berating counsel in front of the jury, berating counsel when the jury's not around, right? All of these things will be taken into account when the case goes on appeal. And I've had judges who are really aware of this. And there's a judge. Is this story time? Let's cut that out. But I've had judges who are aware of that and will specifically say things on the record that are not true. They'll call you nasty things. They will hold your feet to the fire and they'll say, well, I'm not yelling, counsel. I'm not yelling. I'm talking very calmly, because they're trying to pad the record to make it seem like they're not being unreasonable. And they absolutely are. And this is a big problem that we have with judges specifically. This happened to me in Fulton County. And when it's time to name names, names will be named. But the time is not right yet. The record reveals in other instances too, when the trial court wrongly berated counsel in front of the jury. Exactly. So after a number of such instances, Mr. Williams' counsel, out of the jury's presence, which is proper, moved for the trial judge's recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity. Exactly. Displayed bias against Mr. Williams and his counsel and all that good stuff. There have just been all these examples in which the judge has shown bias against Mr. Williams. So then if we read even further down, there's this really important concept called the appearance of impropriety, which I've talked about in other videos before. But here, right, it says that a trial judge shall avoid all impropriety and appearance of impropriety. The Code of Judicial Conduct provides that judges should disqualify themselves in a proceeding in which their impartiality might reasonably be questioned. That's it. The standard is very low, very, very low. People didn't like this. People didn't like this when it came to Fonnie Willis, when I was talking about that case, because they didn't understand the appearance of impropriety. They didn't understand why the bar was so low. And prosecutors, it's a little bit different, right, when we're talking about it over there, but not really. I mean, the appearance of impropriety essentially means that when you are someone in this type of position, you should disqualify yourself when people could think that you could somehow be biased, right? You could be biased against either party or any party in the case, particularly when you're a judge, when you're a prosecutor as well. But the argument was a bit different there because Fonnie Willis having that relationship with somebody else on her team, as I talked about previously, doesn't present the same sort of conundrum as it does here when you are biased against somebody on the other side of your case. Does that make sense? We can get, if you have more questions about that, go back to that prior video. But it says here that the judge in which their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. Within the context of this requirement, the word should means shall, right? The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. Okay, understood. On the one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors must effectively and ethically present the state's case to the jury. Ethically present the state's case to the jury, right? So here, the judge's role, as I said earlier, is to be an umpire, to make sure that the rules of evidence and procedure are followed, and that the proceedings are both orderly, ethical, and fair. So when these other interests come together in the courtroom during a trial, disagreements between the bench and the bar are to be expected, right? The judge is not always going to be on the same page as the attorneys in the case. And the reason for that is because you do have all of these competing interests. So the prosecutors are disagreeing with the defense attorneys, the defense attorney are disagreeing with the prosecutor, and the judge is supposed to be the one in the middle of that. And they're going to side with one side or the other in evidentiary terms. That's okay because you're just trying to apply the law to the facts as presented by the attorneys. But when you start being biased, when you start looking like you're just beating down on the defense attorney, which happens all the time in these cases. Oh, I have so much to say about this, which happens all the time in these cases. And you're just siding with the prosecutor because you believe they're the good guys and they're putting the bad guys away. That's a problem. But in this case, as the attorney says, this is more than just a friendly little fight debate between colleagues and the bench. This is the bench clearly taking the side of the prosecutors. It says the judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial towards the prosecution. Higher courts need not decide whether such bias and impartiality actually existed because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned. Whenever their impartiality might reasonably be questioned. Whenever their impartiality might reasonably be questioned. And it's questioned. Baby, we got questions here. The impartiality is questioned. We've been watching. What's beautiful about this trial versus other trials is that we can see this one on YouTube. Go ahead and click Young Thug, type in Young Thug trial and get ready to have a ball because you can see everything that's going on. And we don't actually have to just read the transcript. We can actually watch the video and see what's going on. Now, I don't know if the Court of Appeals or the Supreme Court rather is going to step in and do that. I don't know if they're going to watch the footage, but if they are permitted to do that, I do think it's going to be pretty obvious and pretty clear what happened here. And, you know, it's really extraordinary. I think people haven't talked about this enough. It's really extraordinary that the Supreme Court stepped in and did give Brian Steele a bond, because I do think if it were any other regular attorney, I don't know that would have happened, but different story for a different day. Ooh, we'd love a 3-part test. So it says here, our highest court has set forth at least 3 circumstances in which recusal of a court is necessary on the ground of mere appearance of bias. even in the absence of evidence of actual bias. So let's get into these three circumstances when recusal of a court is necessary, when you need to recuse yourself. You must recuse yourself, okay? So Mr. Williams does not waive that actual bias has been objectively shown throughout the trial, as well as on June 10th, 2024. Mr. Williams does not waive that actual bias has been objectively shown throughout trial, as well as on June 10th, 2024. But for simplicity, the appearance of bias is also met. Two of these circumstances arise in the case at bar. So there are three circumstances, and at least two of those circumstances are met in the present case. Well, what are they? Let us know. First, the mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in the controversy with one of the litigants, which absolutely happened here, right? There's a controversy with one of the litigants, Brian Steele, because he was held in contempt of court and issued to spend required or ordered rather to spend 20 days in custody. He's not going to have to spend those 20 days in custody, but there's absolutely a controversy here, especially when Brian Steele is saying that there's this ex parte conversation and the judge is like, well, how did you find that out? Tell me how you found that out, instead of addressing why the heck you had an ex parte conversation. Georgia courts have followed this demand for recusal when the judge becomes embroiled in controversy in all of these other examples. So what we see here are these other cases in which the Georgia courts have said that, yeah, there needs to be a recusal because there was some sort of controversy. So the reason for that, the trial judge cannot be both the prosecutor as well as the judge in our judicial system. That's a problem. Where the judge reacted to the supposed contumacious conduct in such a manner to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted in front of an unbiased, impartial judge. I don't see how he gets out of this. This case has got to be heard by a different judge. He obviously got into this altercation with the defense attorney, ordered him to be put in custody, issued a show cause order for everybody who was at the meeting to come back so he can figure out who the source is. It's too much. At this point, he is directly involved. He was involved in that ex parte conversation. I don't know how he gets out of this. Let's go to the second requirement. It says second, due process requires recusal of the judge when the judge takes a role in the accusatory process. And here the judge accused Brian Steele of eavesdropping. Baby, they got him. There's a case in Ray Murchison where it says the highest court, so the Georgia Supreme Court, our highest Supreme Court, explained that the Constitution prohibits a scenario where the judge orders witnesses to appear before him or her in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. This is because such a judge-grand jury arrangement caused the judge to become part of the accusatory process, and thus this judge must be recused from further dealings in this case. Here, Judge Glanville has ordered Mr. Copeland's lawyer and others to appear to give information on a contempt proceeding. He cannot do that. That's ridiculous. So you're being judge, jury, executioner. You are forcing them to come to court, forcing them to present their arguments in front of you, deciding if they're innocent or guilty, and then issuing the punishment. That's not how any of this works. That's ridiculous. Importantly, a trial judge has the duty to recuse itself sua sponte, so on his own, from any proceeding in which the judge's impartiality might reasonably be questioned, including instances where the judge has a personal bias or prejudice against a party. He gotta go. So to warrant recusal, this is another important part. The alleged bias must be of such nature and intensity to prevent the complaining party from attaining. To warrant recusal, the alleged bias must be of such nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment. Wow. To warrant disqualification of the trial judge, the affidavit in support of a motion seeking the same must support the charge of a bent mind that may prevent or impede the impartiality of the judge. So there's going to be an exhibit attached to this motion, which is why the motion is 27 pages long, but the actual motion alleging facts and law is about 15 pages long. So we're going to see those affidavits at the end. I don't know if we're going to go over them in this video, but those will be at the end. Recusal is objectively required when the judge serves as both the accuser and the adjudicator in a case, which is what's happening here. Piriana. Ooh, now let's get into the prosecutors, because we're not paying attention to them enough. We're not saying enough about them because the judge has kind of overshadowed their conduct in this case, but let's talk about them as well. So it says, moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held underside counsel in contempt and failed to reveal any Brady evidence from the meeting, which is extremely important, including the fact that this meeting occurred. The court and the prosecutor should not be working together, but they are. Not the but they are in quotes it's not in parentheses is killing me. Let's go ahead and highlight that. Teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process of law. The court has failed to follow its lawful path. It's improper. It's judge, grand jury, baby, executioner, jury foreperson, all 12 jurors, baby. The judge done played everybody, every role in the court. On a motion to disqualify / recuse, it is the duty of the judge to pass only on the legal sufficiency of the facts. So you're only supposed to be looking at the legal sufficiency of the facts alleged to ask whether these facts would support a charge of bias or prejudice. Period. That's all you're supposed to do. You're not supposed to see, determine whether the allegations are true or anything like that. You're supposed to say whether assuming the allegations are true, not whether you think they're true or not, but if assuming they are true, would a reasonable person conclude that there's bias? And in this case, absolutely. If you assume all these facts are true, which we actually don't have to assume they're true because we sat there and watched it in 4K, but if you assume all these facts are true, would there be bias? Yeah, judge, I'm sorry, but you need to recuse yourself. This conduct raises a strong finding that the judge has become personally embroiled in the case. That's it. So now we get down to the Georgia rule. It says the Georgia Code of Judicial Conduct, Rule 2.11a, mandates that a judge must disqualify himself in any proceeding in which the judge's impartiality must be reasonably questioned or which the judge has a personal bias or prejudice concerning a party or a party's lawyer. So that's pretty much it. I mean, then you got essentially a summary of the case, but at the end, it talks about what witnesses will be called. It says Judge Glanville, lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this ex parte. It says Judge Glanville, lawyers for the state, Love and Hilton will be called as witnesses at trial for the jury. This is embarrassing. To understand this ex parte meeting and determine demeanor and credibility. You got the prosecutors handling the case being called during a trial to question whether they had this improper meeting. That's wild. And it looks terrible. Additionally, Mr. Williams demands all ex parte meetings to be disclosed. Instanter, right? Now, in order to properly reveal the full extent of all violations of law / ethics. Again, lawyers for the state, Love and Hilton, and Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial goaded by conduct of these parties. Oh my God. He said he called the prosecutors and the judge, Periana. So you saw there the signature page on page 16, Brian Steele and probably Keith Adams. Yes, that's right. The two attorneys who are representing young Thug. And right here you have the exhibits, which are, this first exhibit is the order of contempt written by the judge. The second exhibit are the affidavits of Keith Adams and Brian Steele, where they're just going to go over essentially what happened in court that day, just summarizing the injury that they received and why the judge was wrong. So that's what that is. And you can read through that, or you can just go ahead and watch it on live TV and see what happened. So that is going to be the motion for recusal. My thoughts on that is that the judge is going to have to recuse himself. I honestly, I don't see how he could possibly get out of this. I don't think there's an out for him on this one. He's got to go. So that means that the case is going to be heard by a different judge in Fulton County, and that judge is going to determine whether this current judge is biased or needs to recuse himself, and then we'll go from there. I'll tell you my prediction on that. Unlikely. I don't know that another judge is going to find that the judge acted improperly or needs to recuse himself, particularly another judge in Fulton County, the same county in which that current judge is the head judge. He's the chief judge of Fulton County. So he's got to send it to another judge that is not the chief judge. So I'm not going to say his inferior because they're kind of all, it doesn't really work exactly in that way, but another judge in Fulton County that he works with and likely probably supervises or talks to, that judge is going to have to determine the case. And do we really think that judge is going to find Judge Glanville biased? I wouldn't count on it. Thanks for tuning in.